Hi, my name is Heather Tenney, and I'm a partner here at Tully Rinckey, focusing primarily on federal employment, military, security clearance matters. As Brittany said, today our goal is to discuss a little bit about the actual consultation process, and with that, we'll talk about some of the probably most common areas of legal consultations as an overview. So specifically, what we hope to cover and what we hope you'll learn today is understanding what a legal consultation is, the timelines and sort of guidelines for when you should probably speak to an attorney, what you should have prepared when you're speaking with an attorney for the first time, what would happen after you speak to an attorney in that legal consultation. And then, as I said before, we hope to cover a bit of an overview of some of the specific federal employment matters that Tully Rinckey can assist you with. Although, again, it's not an exhaustive list, but we're going to talk about some of the more common areas that we tend to talk about a lot. So what is a legal consultation? Well, generally, it's a conversation at its very core. Ultimately, what a legal consultation is about is an opportunity for you to speak with an attorney who has the opportunity to understand your particular legal concern and allows the attorney to advise you on your options. At Tully Rinckey, we have a dedicated client relations department that has the ability to set up and schedule you with one of our firm's attorneys for up to 1 hour to discuss these matters. And because we have such a deep practice, we often have the opportunity to do same-day consultations for those who have urgent and tight deadlines. So what occurs during a consultation? Well, ultimately, most people who are going to be calling us are going to have some sort of legal matter, and a legal matter isn't just a discrete incident. It's usually a set of facts. So the attorney is going to review the facts of the case with you. They're going to identify sort of the pros and cons of your case. So that might be identifying defenses that the other side may have regarding your matter. Ultimately, the opportunity to review documents together and discuss potential strategy. A big piece is also informing you of the different steps that can occur through the life cycle of your case and the potential outcomes that can occur. And that with that goes into the idea of reviewing strengths and weaknesses. And you can even receive legal advice if at the end the plan isn't to actually retain the firm. So ultimately, after a consultation, if there is a determination through the course of the discussion that there is a legal matter and you have something that the firm can in fact assist you with, the client relations team is ultimately going to send you a retainer agreement that's based on the facts and the scope of work that was discussed during the consultation. And once that signed retainer is in place and payment has been made per the terms of the retainer, the case is going to be open and assigned to one of the attorneys experienced in our federal labor employment practice. The person who you consult with, and this is true not only of just Tully Rinckey, but in most firms, is not necessarily the person who would represent you moving forward. Here at Tully Rinckey, we have people who are dedicated to doing consults themselves. But again, our firm itself has many very experienced legal professionals who then could be assigned to your case moving forward. I did see a question flash while I was talking, and I think this would actually be a good point to talk about it, is that when you do this consultation process and ultimately a retainer is offered, sometimes that representation can occur within the same day. Now, obviously, depending on how long it takes you to decide whether or not you want to retain and whether or not you want to, and you are able to pay and sign the retainer, that's obviously going to affect that. But the sooner you are able to make that decision, make payment, execute the retainer, then the case gets open and the case gets assigned. and the case can be moving forward. Your assigned attorney reaches out and gets to work on that matter. Some of our matters do require very quick action. For an example, I did a consultation at 9 a.m. this morning. That client's case is opened, it's assigned, and they're moving forward because that person has a very tight deadline. And that can happen in many cases. So when is it that you should talk to a attorney about your federal employment matter? Well, frankly, as early as possible. Now, some things, it may not have really, obviously people don't have a crystal ball, or, they're not, psychic. So sometimes, you might be, is it too early? Well, generally some things that would absolutely be a time that should give you notice that talking to an attorney would be a good idea is if you ever receive any type of notice, if you're being told you're under investigation, here's this, documentation saying that you're actually being noticed that they want to try and remove you or discipline you in some fashion. Those are certainly times that are very clear opportunities and examples of when you would want to talk to an attorney. However, there are some times that maybe it hasn't risen to that, but you're just getting a feeling. Maybe you've been experiencing some unfair treatment in the workplace. Maybe you had an unfavorable conversation with a supervisor and think that that's leading to something even though you've not been formally notified. It's always a good idea to talk to an attorney to get, advice that's from a source that isn't aligned with your agency, doesn't have any sort of ulterior motive. The problem is a lot of the things that you talk to and a lot of the people you talk to within your organization, like HR, like even EEO, those people are ultimately agency employees. So their advice is sometimes a bit tainted by the fact that they have that relationship with your agency. So it's good to get an outside perspective for people who have experience in dealing with these types of matters, to get an opportunity for you to learn what your rights, responsibilities, are there deadlines that you don't even know might be happening because of what's going on. There's also times that even when you receive something and you see like, oh, well, I have X amount of days, maybe I have 30 days for something. It's usually a better idea to talk to an attorney sooner in that process than closer to that 30 days. Because number one, if there's going to have to be some type of response, waiting until the last minute is usually going to, inhibit the attorney from maybe even representing you at all, but certainly from preparing the best response. Also, too, mistakes can happen during the filing process. So waiting till the last day or near the last day of a deadline is never the best practice. You never know when there could be technological issues, environmental issues, mistakes in terms of, even the counting. So it's always better to get in early, have the opportunity, make sure your thing is, filed in its proper place, and not worried about did you, get it, in just under the wire. So as I mentioned earlier, I want to talk about a couple very common federal employee topics that come up over and over and over again. One being EEO. EEO is probably the most common thing that we talk about in consultations. EEO is going to be when you are alleging that you are suffering some type of adverse employment action, unfavorable treatment that is motivated by race, national origin, color, sex, disability, age, religion, retaliation for engaging in EEO activity. Every EEO complaint for federal employees, now we're talking about federal employment, there's obviously different issues for things like private employment, but for service members, there's different rules. But in the federal employment world, every EEO complaint starts off as an informal complaint. You do not choose between informal and formal. It is always an informal complaint. In that you're going to be asserting what the bases for your discrimination claim are, what are the different discriminatory actions, when did they occur. In the informal process, you're going to have the opportunity to either participate in what they call traditional counseling or ADR, which is mediation. Now, in a consultation, the questions that are often going to be asked of you if you're in this phase is, what are the bases? When did the events take place? Are you currently in the mediation process? And that's something that obviously counsel can assist you with. Ultimately, at a certain point, if the matter hasn't been resolved through negotiation or settlement, you're going to get a notice of right to file a formal complaint. Now that's a very important document because it has a specific deadline. So when you receive that, you have 15 days from the date of receipt to then file your formal complaint. And with your formal complaint, then you're reasserting the different claims that you have of discrimination. So the different events, the different conduct that you believe is discriminatory, retaliatory, examples of the hostile work environment or harassment, what those bases are. And then ultimately what's going to happen out of that is if you've made what are considered timely complaints that state protected bases and are actionable claims if proved, then those claims are going to move on to an investigation. And an investigator is assigned. You're going to get your statement done. Management officials are likely going to have their statement done. Maybe other witnesses, documents are going to be gathered ultimately to prepare a report. So if you're in this phase or right before this phase, during when you're going to have a consultation, the questions that are generally going to be asked is about, did you receive that notice of right to file formal? If you have, when? If you've already filed, did they accept the claims yet? Are there new things that are happening that may require amendments to your complaint? If you've been in it for a while, have you actually received that report, what they call the ROI, and when did you receive that? Because at that point, there's going to be certain deadlines that are necessary for you to make what they call your elections. Are you going to go to the EEOC? Are you going to elect a final agency determination? A final agency determination is where the agency decides whether or not discrimination or retaliation has been substantiated, whereas if you ask to go to the EEOC, you're electing a hearing before the EEOC where an administrative judge is assigned and the case processes through there. Ultimately, if you're at that phase during a consultation, we're going to talk a lot about what's happened up to that point. We're going to talk about where you are in the process. Have you made your elections? When you did that? If you haven't, when did you get the ROI? Then if you're further along, that, have you gotten orders from the judge? Are you making discovery requests? Have you received the orders that have certain deadlines? When do they open? When do they close? Have you received anything like an agency motion? Have you received any deadlines for the actual hearing itself? These things are very important. Missing these deadlines could lead to your case being dismissed overall, but even if it doesn't rise to that level, it could have a significant negative impact that could make it very difficult for you to win your case. Often people not only benefit from having counsel throughout this process, but particularly at the hearing stage, it can be very difficult to represent yourself in these types of proceedings. So getting advice and talking to somebody about what that process is and retaining counsel is often very beneficial, especially before the initial conference in front of the judge, because a lot of the things that are going to happen during the process are set then. So having an attorney who can shape your battlefield is often your best practice. Now, if you had a hearing or if you got a final agency determination, there's going to be deadlines for you to appeal to what they call the OFO, the Office of Federal Operations. And those have very, again, specific deadlines. Usually from the time you get that final agency determination, you're going to have 30 days from the time that you got that to file your notice, if not your appeal itself. Now, what are some successful tips for these types of consultations? Well, again, a consultation is a story. So be prepared to tell your story, but also, these consultations are up to an hour. So, it is a good idea to have sort of a roadmap of where you want to go to keep yourself on topic, but also be referencing what are the kind of most important things. When did they happen? What are the specific, incidents that you're alleging to be discriminatory? I will tell you, I do a lot of consultations. I sometimes do up to 8 a day. And one of probably the least effective things that happen in consultations is people who treat the consultation like they're reading a play, where they're saying, well, this person said this and that person said that. Now, again, it's not that that stuff won't be important to hear what potentially other witnesses may have said, but during the consultation, you do want to try and be concise and be able to address those things that are, what are the actions? When did they happen? What do you believe to be the discriminatory basis? Because that's going to lead to the most effective consultation. You know, telling the whole story when you're narrating what different people said may overall long-term be beneficial, you know, in trying to address who would be witnesses, but not usually the most effective thing in a consultation when you're trying to, you know, get the story out so you can get the advice from the attorney and find out what the attorney may be able to do moving forward. Now, obviously, it's always important to be on time and be ready to discuss. Some people will draft a narrative, which is a good thing, usually more for you than the attorney itself, because the idea isn't just we read a narrative and then we talk to you about it. It's that you're going to tell us the story. But a narrative can be helpful for you to be able to keep that path, keep that, you know, on topic and be concise. But always be prepared to discuss the issues. So a lot of people think, oh, I sent a narrative in, so I don't have to say anything. And it's a consultation, it's a conversation. So you have to be prepared to talk. Another very common area of consultation, not a particularly pleasant one for most people, is proposed disciplinary actions. Now, this can start off not as actually having like a letter of reprimand or a proposed suspension or a proposed removal in hand. It can start off with just, I'm being investigated for something. And, you know, that can be a very good time to talk to an attorney, because sometimes during the investigation phases, we can raise issues that ultimately lead to a favorable conclusion without you ever having to have faced the proposal for discipline. But sometimes, whether it's because people didn't recognize the risk and thought that, oh, well, if I just explain my side of the story, everything will work out, you know, things do escalate and they get a proposed disciplinary action. And that can be, you know, letters of reprimand, it can be proposals for suspension, you know, anywhere from, you know, 1 day to, you know, indefinite. They can get demotions of a pay grade. They can get, obviously, unfortunately, the worst case scenario, the removal. Now, these are going to have very specific and tight deadlines. And it's important, as much as this is often a very traumatic experience, receiving something like this, and people sometimes don't want to deal with it, it is important to look the document over when you're, you know, thinking about talking to an attorney, even just for your own edification, because the stuff that's on the front page is not generally telling you when it's due. A lot of these documents say that they'll say something about 30 days. Well, say with a removal, 30 days is the earliest it can become effective, but it isn't what your deadline is for response. Usually what your deadline and what your requirements are for responding is towards the back of the document, usually near the second to last page. And it's somewhere usually between 7 and 14 days. Some agencies are a little bit more open, where they give like 21 days. That tends to be more like IRS sometimes gives that long, and Treasury. But for the most part, when you're talking about DOD and most agencies, it can be anywhere as early as 7 days, and that can be 7 actual days versus business days. But the sort of core is usually between 10 and 14. But again, the sooner you get into, you know, booking a consultation and having that discussion, that's really important, because that develops what your strategy is. And if you are going to retain counsel, we often need all that time to be able to do a successful response, because in those responses, we're usually going through all the evidence, and if they haven't provided it, we're having to ask for it, and I'll often have to have a fight with them about it. And then we're going through all of it, and we're line by line looking at the different problems that exist with it. We're obviously trying to develop more information that might be from your perspective, because information they didn't gather from witnesses they didn't talk to. Also, information about mitigation, your favorable performance and career and life, all that stuff takes time. So the earlier you reach out after receiving something like that, the better. Now, with some of these actions, there's going to be very specific types of appeals for most employees. So if you are removed and you're non-probationary and you work at a majority of federal agencies, you're often going to have the right to appeal that removal to like the MSPB, the Merit Systems Protection Board. There might be some other circumstances, obviously people who are in unions and have collective bargaining agreements, they may have the ability to grieve. There also might be certain disciplinary appeals boards for certain other types of employees, like Article 38, or excuse me, Title 38 employees often have these things called disciplinary appeals boards. But again, very important, even if you did not reach out when you had the proposal, but you now have a decision, very important to talk to an attorney about what your options are for appeals, because again, these things have deadlines and they also might involve choices. So having the ability to discuss what those choices mean, what the pros and cons between them are, certainly something you want to do. Now, if you do have, things like an MSPB right, then there's a whole process associated with that, where it's a lot like the EEOC, where you're going to, have discovery, you're going to have a hearing, there might be even appeals after that. So very important to, if you going through any of these things, very important to reach out to counsel, let them review what you have, let them discuss with you what your options are and potentially represent you, because these things, while they're administrative, they have all the trappings of legal process. It can be very difficult to represent yourself. Not to mention, even if you have legal experience, it's often very difficult to represent yourself in general. There's an old joke about the attorney who has themselves for a client has a fool for a client. Well, we all kind of joke about that, but really what it gets at is the idea of, it's also very difficult to be objective about your own facts and circumstances. You know what happened, but the people who are making these decisions don't, and they're not just going to take your word for it. And sometimes it's hard to see where certain things may be true, but the evidence might not be that strong. So getting somebody who can help you evaluate your case and help you to put your case in the best position possible is usually in your interest. So what are some tips for successful disciplinary action consultations? Well, obviously sending the disciplinary action. Now, if you're prior to the actual proposal for discipline, but you've gotten, say, a rights warning, or you've received an investigation, like a finding, then those are the things you're going to want to send, with your consultation, so they can be reviewed during the consultation and that discussion can take place. Also, too, again, a narrative can be helpful, but again, more helpful for you to be able to define your thoughts and help you to be able to best convey them. They don't supplant the idea of having the discussion with the attorney, but it can be helpful. It also can be helpful if you then become a client of the firm, to then use those as a basis to then turn into like your sworn declaration or sworn statement. So having going through everything and sort of doing your version of the events can be very helpful, not only for you to be able to share those events during the consultation, but also down the road for the representation itself. Now, if you are aware, if you're actually have received the disciplinary action and you're aware of others who have been accused of and proposed discipline for the same or very similar conduct, and you know that they received like a lesser punishment, having that information is important, because that's often a factor in these. If someone else was punished for the exact same thing, but in a much more favorable way, that could be an argument that that's improper, that that's not a proper like Douglas factor analysis. It also could get into discrimination or reprisal as to why you're facing a more harsh punishment. So obviously, a good thing to think about if you have that information, to certainly share with your consult attorney. And of course, like anything, be on time and be ready to discuss. Again, a lot of these circumstances can be very traumatic, but we're here to help, but we can only help as much as you help us. If we can't be pulling teeth to try and get the information. Okay. So another area is what we call OSC complaints. OSC complaints, that's the Office of Special Counsel. And that's generally going to be where you're making complaints of like whistleblower reprisal or reprisal for other protected activity, or certain other what they call prohibited personnel practices, which is things like, unlawful like hiring actions, nepotism, violations of like the merits principles, certain discrimination for non-EEO bases, although EEO discrimination is also a prohibited personnel practice, but obviously it has its own specific type of complaint process, which is the EEO process. So ultimately, some agencies, though, do not fall under the jurisdiction of the Office of Special Counsel. So specifically, just as an example, the Postal Service, USPS, if you believe you are the victim of whistleblower reprisal, you would not file an OSC complaint because they do not have jurisdiction. Ultimately, your complaint would go to the agency's Inspector General. Possibly, obviously, you could do something like a congressional complaint, but there's not jurisdiction for the OSC to investigate, whistleblower reprisal, no matter how good your evidence may be. Doesn't mean that it couldn't still be used, especially if you're facing some sort of discipline. It could be part of your defense in a different process, but you wouldn't be filing an OSC complaint. So, obviously, if you are experiencing these types of things where you think that you are either you've observed some sort of prohibited personnel practice or you're the victim of a prohibited personnel practice, specifically like reprisal for engaging in like whistleblowing or protected activity, good idea to talk about those matters with an attorney, talk about what your rights are. Sometimes there might be other options other than filing an OSC complaint. So it's a good idea to talk to your attorney about, what is my best option? Like specifically, another consultation that I had today was regarding somebody who had gone to the OSC, making a reprisal complaint and another type of prohibited personnel practice complaint. However, what the consequence of all of that was is that the person was removed. And they could have gone directly to the MSPB, and had they talked to us at the time, we would have told them to do that. And now there's some issues about, what the timing is, and, did they hurt their case by taking that other step instead? So good idea to get advice, even if you're not going to retain. This isn't always about like, oh, I'm going to talk to an attorney and there's going to be some hard sell for them to represent me. It's about you getting information about what your rights, obligations, and options are. And a lot of these things, as much as the internet can be a nice tool, it's also a source of a lot of bad information, particularly, unfortunately, right now, a lot of the AI. AI misses nuance when it comes to the law. They might be able to survey a lot of stuff very quickly, but there's a lot of things about the law that it can be very unclear. And in fact, I frequently do little tests with AI. So I ask a question of AI on an issue, like I'll see a consult that I'm having later in the day. I'm like, well, what would this person, if this person was looking this up on AI, what would they find? And I'll often find that they would find misinformation. They would find things that aren't actually correct. So good idea to get an advice from people who actually do this stuff day in and day out. Now, when you file an Office of Special Counsel complaint, if the matter is not resolved or the OSC can't make a finding or even makes an unfavorable finding in some instances, that doesn't necessarily end the process. In many instances, they can give you what's called an individual right of action that allows you to file with the Merit Systems Protection Board, where you may not have been able to go directly, but there's going to be time restrictions on that. And there might be some other considerations. So another good time that if you hadn't talked to counsel and hadn't been represented on the OSC complaint itself, if you get that individual right of action, a very good time to talk to an attorney. So, and again, obviously, because the time constraints of a consultation, of a webinar on consultations like this, we can't get into every topic area with as much depth as we just talked about, EEO, disciplinary actions, OSC, as some of the other topics. But again, we talk about, the full gamut of federal employment issues. But some of the other probably more common areas that we do discuss are things like disability retirement. That's been coming up a lot lately. What the different criteria are, what are the best practices, things like if you do get a decision and the deadlines, then ultimately the what might benefit you in terms of like arguing for reconsideration. Obviously, if you've got a final decision, there's going to be specific deadlines for purposes of going to like the Merit Systems Protection Board for appeal. Now, administrative grievances are another area we talk about. We don't tend to talk about negotiated grievances. Those are the grievances that go under the collective bargaining agreement. Those are usually handled by the union, but many people don't have the ability to go through that process, but they do have the ability to grieve administratively. There are specific timelines, and there also are often restrictions to what you can grieve. So that's a good idea to speak to an attorney about, if you face something like, for an example, a common thing that is, or two probably common things that are grieved are letters of reprimand and unfavorable evaluations, like performance evaluations. So good idea to talk to an attorney about kind of what to do, best practices, and potentially obviously have representation through that process. Another area that comes up a lot are desk audits, or what we call reclassification appeals. That's where you might be working at a specific grade, but you believe based on all the duties that you're performing that that's an incorrect grade and that your grade should be changed. There's some kind of quasi versions of this where you may think you're working outside of your position description or your position description isn't accurate. Those are good things to talk to an attorney about, because there's different processes and procedures to try and address those. And sometimes if you kind of do your own research and go and say do like an OPM desk audit or reclassification appeal, but you don't have a current correct position description, then you will likely be unsuccessful in your OPM desk audit. Also, OPM is kind of notorious for downgrading people, so usually you don't want to go to OPM first. You usually want to try and address it with your agency, get a decision, and then appeal the decision if it's unfavorable to OPM, but not go to them first. Also, another area that we talk a lot about with people are debts. There are situations when people might have received an overpayment, or they got some sort of incentive, but they then didn't meet the conditions of it, and now the government is coming back to try and collect. Either if they are currently a federal employee, they're trying to take money out of their paycheck, or if they've left, they're trying to assert a debt and may even try and garnish wages from a new position or take your tax refunds and all these things. That's another area that obviously we can assist with, explain kind of the process of, how you potentially dispute debts, or if it is a valid debt, how you seek waiver of them, and what are the best practices and what things can be offered there. There are some deadlines associated with that. Not sometimes as harsh, although again, everything kind of has its own rules. Some different agencies have very harsh deadlines. Others, you have a certain, like sometimes even up to 3 years or more to file, say like a waiver. But if you file it earlier, if you file like within 30 days of them first asserting the debt, you often can get them to stay collection while that adjudication is pending. But if you wait and wait and wait, they might be taking money that whole time, and obviously that's not a good position to be in. Obviously, a topic that's been coming up quite a lot lately is reduction in force, DRP, early retirements, discontinued retirements, management directed reassignments. These are all things that talking to counsel can be very helpful in. Reduction in force, there's often a lot of issues with the notices. There may obviously be issues once you have been removed. You're often going to, if you've been removed, you're going to have the right, or even not removed, but have been demoted a pay grade. You're ultimately going to have the right to appeal that to the Merit Systems Protection Board, having counsel for that. These are incredibly complicated issues. In fact, frankly, a lot of the appeals right now are kind of like something seems wrong, but we don't even know what the wrong is because there's no documentation. So it can be very difficult if you're trying to represent yourself in trying to negotiate that discovery process, trying to get those documents. So good idea to talk to counsel. Good idea to talk to counsel on any of these things, because in some instances you may be going to take certain steps that if you do them, you might be in a position where you might be compromising other opportunities you had, or might even be waiving those. So good idea to discuss, what your options are, what that means, so you're making the most informed choice. So what are some bad habits that you should avoid during consultations? Well, as I talked about a little bit before, obviously, try and be concise, but being concise doesn't mean withholding information. Many times people, don't want to acknowledge maybe some of their, things that they have done wrong, that things that maybe they did do whatever's in that proposal for removal. That's fine. You're talking to an attorney, you have confidentiality in the nature of a consultation. It's better for us to know these things so we know how best to develop the strategy, obviously how best in the consultation to advise you. Holding back facts because they maybe don't make you look good, or you don't want to share something because it involves somebody else. Remember, there's confidentiality. If you don't tell the story, you're not going to get the best advice. So it's important that you are open, candid with counsel when it comes to the good, the bad, and the ugly, for lack of a better term. Another thing is, some of these cases can be very document intensive. They can have hundreds, if not thousands, of pages of documents. Now, obviously, during a consultation, we do not have, time for hundreds and thousands of documents to be reviewed during the consultation. And frankly, sometimes it's better to send more than less, but if there's a very specific document that is very important and you want it reviewed, making sure you send that document and not bury it in thousands of pages of other stuff, is very important as well. Sometimes you get kind of the forest for the trees problem. Somebody sends me 200 pages, but they really wanted me to look at this 5-page thing. I can't find the 5-page thing now, so good idea to obviously focus on the things that have like the deadlines, the action items. So if you've got a proposal for removal, send the proposal for removal. Don't send, the 2 years of notes that you have about, all the different emails between you and this person. Now, are those things maybe going to be relevant for the response? So if you retain us, are we going to gather all those things? Yes. But during the consultation, there's not going to be time to do that, and it's sort of confusing the issues. Sometimes too, people book consultations because they want somebody to tell them that they're right. We all like that. We all like when people agree with us. We all want to be right. We all hope that we're doing the right thing. But the reason you have a legal consultation is to get the attorney's perspective. The attorney's perspective often has, it can be, at least during a consultation, a little bit of like a devil's advocate. We're ultimately trying to address the fact that, there might be defenses, there might be negatives, and not listening to the attorney's perspective is often a big mistake. It's not like we're saying, hey, this is exactly how this is going to go, but these are the considerations that you have to take into account when you're deciding, number one, whether or not you want to pursue it at all, but the things that we may have to be much more mindful in how do we address, because this is what the other side is going to be thinking, this is what they're going to be doing. So I want to take a bit to see the different questions, and hopefully we can address some of those. Let me go. Somebody asked a question how they can talk to an attorney of the firm without sending a general or signing I think they mean signing, it says signing a general power of attorney. We don't do powers of attorney for the consultation. Ultimately, for most consultations, ultimately, obviously, you become a client of the firm, you will sign a power of attorney because we will need that power of attorney to be able to act on your behalf for a majority of matters. But generally, you're not signing a power of attorney for the actual consultation itself. In terms of, there was a question about what's the relationship between an RRR and the MSPB. how is an RRR used in connection with an MSPB appeal, particularly regarding federal reduction in force? Well, again, actually, an RRR kind of is really very specific to this. Rarely do we see RRRs used. And in fact, I don't know, there was one firm that was doing a lot of RRRs related to the RIF notices. And they were basically, what they were doing is they were trying to get an, we'll call it an advisory opinion regarding whether or not the agency had complied with the Code of Federal Regulations. However, the MSPB hadn't really spoken to it. So then people actually got RIFed, and now there's really no bearing on the RRR. You're going to file your MSPB, or if you're going to be, having your union represent you through like a grievance process, or you're going to do that. But the RRR, ideally, it was designed to try and get a preliminary advisory determination of the legality, in this case of the RIF, prior to it being effective. And in this instance, it really didn't have much bearing. I mean, the real bearing was more from the federal courts that had put, preliminary injunctions on these cases, but unfortunately, the Supreme Court did not carry forward on the preliminary injunctions, and now the RIFs have become effective. Doesn't mean that they're legal. It just means that they're now effective, and now you have the right, if you've been now RIFed, to appeal. There's sort of a general question about veterans and failure to accommodate. I would say that some of these questions are very much designed for consultations. I mean, we represent people all the time. We represent whether you're a disabled veteran or just a person who has a disability in general with seeking out reasonable accommodation. Somebody asked what a federal employee who submits a FOIA request but doesn't receive the response in the required period. Well, very rarely do people receive a response during the required period, and if they do, it's often a response saying we're not going to be able to respond to you within the required period. They're just giving you notice. You can ultimately file in federal court if you do not receive a response to a FOIA, often though doesn't mean you're going to get anything out of it, and you're often going to spend a lot of money. Depending on what your issue is, you may not need the FOIA. If you're saying, oh, well, I'm going to file this because I'm not going to file an EEO until I get the FOIA, file the EEO. You'll get more information out of the EEO than you will out of the FOIA. Plus, there's a lot of exemptions. There's redactions in FOIAs. There's often not those things when you're proceeding through like an EEO case or an MSPB. Somebody asked what the timeline is for a RIF notice. In general, it's supposed to be 60 days. However, an agency can request it be moved up to 30 days. Some agencies have. A lot of the more recent ones, we've seen actually them trying to do them in 30 days. That will obviously be an issue on appeal, is whether or not they legitimately had, a basis for seeking that more expedited proceeding or processing. Oh, I'm sorry, I missed one. There's a question about like if somebody has the union representing them, is there value that can also be had from retaining outside counsel? Well, again, it depends on in what capacity the union is representing you in. Now, some, like particularly say with a RIF, you have to look at your collective bargaining agreement to determine whether or not there's even an ability to seek outside representation, because some union contracts, the collective bargaining agreement says the matter has to be handled through the administrative grievance procedure, or excuse me, the negotiated grievance procedure. Most, though, recently have not. So the question is the union representing you like as part of like a class complaint? Well, then you may decide that you want to pursue your own action, because obviously a class complaint does not necessarily address your specific issues. It addresses the collective issues that the union sees with the action. So it may benefit you to talk to private counsel and pursue your own matter, say like at the MSPB if you have that jurisdiction. Now, obviously, if you get relief from that, you may ultimately have to decide if there is relief from both forms, you're generally not going to get it from both. You're going to have to opt in or opt out of one or the other. So there's obviously pros and cons. Obviously, also having private counsel is going to cost you money that often, you don't pay from having the union represent you because you've already done that through your dues. Yes, I'm just saying yes before I even answer this. Have not me personally, but I've obviously we experienced increased discrimination for teleworkers and I would say remote workers with reasonable accommodations due to the new admin targets on their back. We have seen a lot of issues with people who previously who had before the executive order came out, who had the accommodation of telework and remote work, that they're being asked to basically jump through hoops and have to redo a bunch of things and then being denied. Ultimately, the um, the circumstances are going to be individualized. We've also seen a lot of people who obviously had to apply for reasonable accommodations because they maybe were in a remote or telework position that now has been basically done away with due to the executive order, and they never asked for an accommodation because they didn't need one because their job was already remote or um, was telework, and people are having a lot of trouble getting those types of accommodations. It seems to be there's much more scrutiny at this point over those types of accommodation requests than maybe others, like getting adaptive equipment, getting a special chair or a stand-up desk seems to be much easier than trying to get, teleworker um, those. But again, easier in the sense like people have trouble, but that's another reason why people often benefit from reaching out to counsel and even having counsel represent them, because a lot of your managers or middle managers or even the higher level people think that they can sort of say, no, we don't have to grant this because of the executive order. Well, the executive order doesn't apply to, reasonable accommodations. It's, they ultimately have to comply with the ADA or what they call the RA when it applies to the federal government. So they're creating potential EEO issues. So often having counsel represent you and frankly educating, your leadership can sometimes, get you the relief you're seeking. Again, somebody's asking about powers of attorney. I have no involvement in the booking of consultations, but I would say please reach out to our client relations department. Generally, you're usually not going to sign the power of attorney before, but if you're going to become a client of the firm, you will absolutely be signing a power of attorney for us to represent you. So sort of just a general question about remote work and if you were hired. Again, it goes back to what I was saying. Like people who ultimately were hired remote and now the executive order, I mean, in the short term, the answer is if you don't have a basis to be able to seek like a reasonable accommodation, if you do not go to an office, then you are subjecting yourself to, being removed. They will call you AWOL, whatever. Now, obviously, if you have a basis for seeking out a reasonable accommodation to maintain a remote schedule, then I would advise reaching out. We can try and negotiate those things. But even if you do wind up in a position where they're trying to remove you for not coming back after a return to office order, there's still due process in that. They have to give you notice, they have to give you an opportunity to be heard, but in terms of what the end result of that will be, it's, we don't know. It's going to be based on the facts and circumstances of each individual case. Can the agency justify it? I mean, there is an executive order, that says, no, we're not doing remote and telework under these circumstances. So there's a question about whether or not like verbally asking for alternative work schedules before formally submitting counts as requesting reasonable accommodation. There's not like obviously there is a formal process. Every agency has forms that you submit for a reasonable accommodation. However, that's the process, like the more formalized agency process. You could theoretically go to your supervisor and say, hey, I need X. And you don't necessarily have to even verbalize it as I am asking for a reasonable accommodation. The problem of doing it that way is that you are potentially creating confusion. The person may think that they just have the authority in and of themselves to say no. So often you're not going to get what you want. You're going to wind up having to go down that pathway. So often it's better if you're in a position like that to talk about the issue with counsel, do it properly so there's no confusion and no basis for the agents to say, oh, well, we weren't discriminating against this person. We didn't realize that that's what he was asking for. Also, too, sometimes, when you do things in that regard, and even if the person says, fine, I'll alternative work schedule, that's fine with me, you want a formalized reasonable accommodation request and approval on record, because that person might not be your boss forever, or that person's mind may change, and now there's nothing in there that says that you had an approved accommodation. We see it time and time again that people have been operating for months, sometimes years, under a certain schedule with certain, allowances, but new boss comes in and suddenly no more. And in fact, that happened to a lot of people with this executive order, is that they had what they thought was a reasonable accommodation, but it was never in paper. So now they're asking to have to resubmit for it, and now they're getting denied. Well, I actually have to do another consultation here in 5 minutes, so I'm going to conclude today. But, as sort of a closing, like I said, there are a lot of issues that are going to be very, person specific, that are going to get into your facts and circumstances. So if you do have these types of questions, these types of issues, please feel free to reach out to us. Here's our slide with our information. We have both the ability to book online and with individual representation. Our representatives are available even on holidays, so please reach out, and we would absolutely be happy to assist, and if the circumstances are right, we would be happy to represent you.